We can begin with appearances.
Your Honor, Glenn Hunter on behalf of the prosecutor's office in this county.
Thank you. And we'll wait till everyone is in the well of the courtroom to commence this hearing.
My name is Joseph Thomas. I'm counsel for plaintiff Brian Cortland.
Thank you. I have some remarks at the outset to clarify the posture that we're at right now, and also to indicate to the parties where the court currently is in its thought process, as well as what would be most helpful for the court to hear oral argument this morning. First, I would note that the posture is that we are here on, in effect, the merits hearing in this matter. There was a summary judgment motion filed. The briefing thus originates in the posture of the dispositive motion. However, at prior hearings in this matter, the court indicated it would be merging the consideration of these matters for the purposes of this hearing and allowing the petitioner or plaintiff to file a server reply, given that in any type of action like this, the burden is borne by the plaintiff, and thus they should have the final word in the briefing. So this is the merits hearing on this matter, just to make it clear. Additionally, there is really only one issue that the court wants to hear argument on this morning, and that is whether or not the law library or the law library board is part of the judiciary. The court is not going to deny relief to the plaintiff in this case due to what has happened with respect to the creation or removal or existence or lack thereof of the law library board. The statute is clear that counties such as Lewis County must have a law library board of trustees, and it is clear from the record that there's no genuine issue of material fact that there is some operation akin to a law library happening. It is not currently, apparently, being overseen by a law library board of trustees, but that does not mean that those operations at the county level are not occurring, and thus it is appropriate, in the court's opinion, to reach the underlying merits of this issue of whether or not a law library or law library board is part of the judiciary, and thus whether or not it is properly within the purview of the Public Disclosure Act. Given the posture and the fact that the law library board is no longer, it appears, operating as a matter of going concern, the court does find that the form of the request and the caption of this lawsuit are appropriate in these circumstances, given what the practical reality is and was on the ground with respect to the operations of the law library board. That being said, it appears that both parties have identified what is really the meat of the issue in the briefing, and I appreciate the quality of the briefing from both parties on this point, and that is whether or not a law library and the board that governs it is part of the judiciary, and thus whether or not it is within the purview of the Public Disclosure Act. I'll let the parties process and take notes on that for a moment. I will also indicate that my preference regarding how to proceed with oral argument on this matter is to hear from the county first, because the way that I have already articulated the direction and where I am heading so far, I believe that would be most fruitful. However, this is in effect the only real matter we have this morning, and so if there needs to be additional commentary or argument from either side, I will allow the parties to do that. I will also not limit the parties in terms of time, but I will remind both counsel that you are professionals and you know how long something may or may not be helpful to argue for. So with that being said, I will hear from the county first.
Your Honor, Glenn Carter on behalf of Lewis County. Thank you very much, and thank you for focusing our argument this morning. Your Honor, the two pertinent cases that decide this issue that's before you concerning whether the purposes of the Public Records Act, the Law Library Board is a judicial agency, are Nast versus Michaels and West versus the Washington District Municipal Court Judges Association. Nast versus Michaels is particularly appropriate because in that case, the stipulated facts were and the court's findings were that the court clerk for King County was an executive agency. The court found that the court clerk in King County was an executive agency under the charter, the King County Charter, and therefore was financed and operated as an executive agency and therefore part of county government. The reason that that's pertinent to our argument this morning is because that's the argument that Mr. Cortland is making in this case. He argues that the agency here involved, the Law Library Board, was an executive agency, meaning in his terms that it was a county agency. What is very interesting about the Nast case, and you'll recall the facts in the Nast case, that the court clerk, acting as that executive agency perhaps in its view, and responding to a budgetary crisis, increased the costs for accessing and copying Superior Court files. Those people who were affected by those cost increases sought to bypass the increases by making public records requests for access to and copies of those court files. So the issue before the Supreme Court was whether this, quote, county, unquote, executive agency was acting in the capacity of a judicial agency for purposes of the Public Records Act. And what is noteworthy of that holding in that case is that notwithstanding organizational, it was an executive agency. And within the county, the Supreme Court found that when it was the custodian of court records, it acted, quote, within the judicial realm, unquote, for purposes of the Public Records Act, and was a judicial agency for purposes of the Public Records Act. The key passage in that case, which you'll find at 107 Washington 2nd, 300, at page 305, at the bottom of the page, and I'm just going to read a few sentences which are pertinent to this issue that's before us. Quote, the King County Department of Judicial Administration, by its name, falls within the definition of agency. Furthermore, King County Charter, Chapter 350, Section 20, provides that it is an executive department. The department, however, is a unique institution. Although its funding and directives place it within the executive realm, its function as custodian for court case files places it within the judicial realm. It then quotes from the Coles case and goes on to say, court case files are generated by litigation activity occurring solely in the judicial branch of government. A decision regarding PDA access to court case files should not vary between superior courts because of the administrative alignment of the clerk's office, unquote.
So the county would argue that NAS stands for the importance of focusing on the function of the entity at issue. Is that fair?
Precisely, Your Honor. And the second case then that's applicable is West versus Washington Association of District and Judicial or Municipal Court Judges. And what's interesting about that case, again, to recall in that case, that the allegations that were made by the plaintiff was that it was not a judicial agency. Number one, it was created by statute by the legislature. Number two, it was largely financed by non-judicial funds. And number three, it engaged in what Mr. West thought was non-judicial conduct, that being lobbying work. That's the way that he phrased it. Most of the case was about lobbying and lobbying expenses. But with the Court of Appeals, this isn't a Supreme Court case, the Court of Appeals found, though, that functionally it was acting as a judicial agency because what the subject of that association is the improvement of the courts. of the operation of district and municipal courts. Yes, a lot of that is going to the legislature, a lot of it is reporting to the legislature, but what the function was the improvement of the courts and a forum for judges to speak to each other for the improvement of the courts. And that was deemed by that Court of Appeals to be a judicial function, not a function, a non-judicial function. And because it deemed that discussion, that drive for the improvement of the courts to be a judicial function, it found that it was a judicial agency. It went on to find that the membership, which was entirely made up of judges, confirmed that it was a judicial agency as well. Now, Your Honor, the membership should not be taken as an indispensable element of the test, because in Nass versus Michaels, again, the membership of that agency was in the executive department and the county department, and it still was found to be a judicial agency when it acted as custodian of records for purposes of the DRA.
Did Nass state exactly who headed the Department of Judicial Administration?
Your Honor, let me grab it. The dissent, Your Honor, if you look at the dissent was by Judge Durham. It has a little more information with respect to what was being alleged. Let me see if I can find that page. What the dissent said is under the, make sure I got it, yeah. And this is at page, bear with me, 311. It's probably in the middle of the first column of page 311. Under the PDA, agencies include county departments. Then it cites the statute. The King County Department of Judicial Administration is a county executive department. King County Charter 350.20. Hence, it qualifies as an agency. And then it goes on to say that the majority holds, however, that the Department of Judicial Administration is not covered by the PDA because the PDA does not cover courts. But it doesn't tell me who actually headed it. I apologize. It may say that I don't see that the dissent says that. So it might be in the Court of Appeals record. I'm not sure. I don't know for sure.
Okay, thank you.
I would go on to note, Your Honor, that West, even if membership were an element of our test, that the original act that we're talking about, the County Law Library Act, as you know, created 5 positions on law library boards, of which 4 were occupied by judges. I think that it's clear that it was intended by the legislature to be a judicial agency for purposes of its organization and what it did. It also performs a quintessential judicial function. I know it hasn't been perhaps keyed in on by the other party or the court in this case, but the obligation to maintain an adequate law library is a U.S. constitutional obligation imposed on the state.
So I have a question. The county, in its briefing, indicated a lot in terms of that argument that prisons or jails need to have people in custody at those locations need to have access to law libraries. Would the county argue that records regarding those law libraries are also exempt from the Public Records Act?
Your Honor, I would. The function is a judicial function. I don't know how often those functions, whether a jail law library or a county law library, are separated. The access to the law library is, of course, not limited to inmates. It's also something that is useful for purposes of the courts and, of course, the history of it. You know, I mean, we're going back to the 1919 Act, and we're going back to colonial history in the United States. And that is that courts have generally been the entities that have maintained law libraries, particularly in rural areas. The reason we had the Act in 1919 is because there was a need for those facilities to be adequately supported. And that's why the statute says that the Law Library Board may make a demand upon county government for adequate space, light, and heat. That kind of a demand is not necessary and put in statutes when they're part of the same government. The reason that the demand is put in there, otherwise the statute would read, county shall provide adequate space, light, and heat for law libraries. It doesn't say that. The Law Library Board may make demand in section 066 of 27.24 upon the county government for adequate space, light, and heat. The reason for that is because the court is, of course, a state entity, and the county is the VOCC, and that is a county entity. So it is a provision in a state statute for a state entity to make a demand upon the county for support.
Council, I'm going to take you back to something briefly, which I was capable of just looking up and shall take judicial notice of for the purposes of putting the NAST case into perspective. The King County Charter at, I don't know if these are chapters or sections, but 350.20.20, which establishes and defines the Department of Judicial Administration and has not been altered since 1988, which I guess postdates NAST by 2 years, but I have no reason to believe that it is any different than what happened at the time of NAST. The first sentence says, the Department of Judicial Administration shall be administered by the Superior Court Clerk, who shall be appointed by and serve at the pleasure of a majority of the Superior Court judges in the county. And I understand that while the charter may put that into the executive portion of county government, at least from the court's perspective, that would appear to be a strong indicator that the membership component would be weighing in favor of finding the Department of Judicial Administration as being part of the judiciary because it would be effectively under the control of the judges.
Your Honor, I agree 100%.
Okay.
The clerk of the court under the Constitution, Article 4, Section 26, is the ex officio clerk of the Superior Court. The county clerk is an elective office.
Not in King County.
That's true. But in Lewis County it is. And under the charter in King County it is not. But the argument that has been made by the plaintiff is that the county clerk himself is a county officer and a county agency. So it's still the same argument. The argument being that the county clerk is a county department and therefore, for those purposes, must be an agency under the PRA. And what we find is that under Article 4, Section 26, when the county clerk functions as the clerk of the Superior Court, which is how the county clerk functions when they're custodian of court records, that in that capacity, they are operating, quote, within the judicial realm, unquote, and for purposes of the PRA are a judicial agency. Again, what I'm trying to just stress here is that there's been an argument throughout these cases on focusing on the technical organization of the county and saying that here's an organizational chart. The county clerk, the law library board, these are county agencies in their view. I'm not saying there is such an organizational chart, but that's what he's saying. And that isn't the way in which the Supreme Court addressed it in the NAST case. The Supreme Court addressed it as saying that the function here is a judicial function. And we submit that the operation of a law library is also a judicial function. That is a judicial administrative function that has historically in American history been performed by the courts. It is one that is appropriate to provide the judges and the members of the bar with access to appropriate court materials in doing what is judicial work. And that the 1992 amendments to that statute that provided for 3 members of the local bar to replace 3 of the Superior Court members on law library boards does not take it out of the judicial category. The reason being is that they practice within the judiciary. Their interest is a judiciary-based interest in that law library board. Simply because they don't wear the title of judge does not mean that it isn't part of the judicial branch when it functions as maintaining that judicial library.
And Counsel, I'll indicate, I agree with you that the relevant analysis here is that in the Koenig or Koenig case, I don't know how to pronounce that name in this context, but for the benefit of the record, I'll read it out. City of Federal Way v. Koenig, K-O-E-N-I-G, 167, Wash 2nd, 341. It's a 2009 decision. And it says that this turns on the Where is the relevant portion here? I'm sorry, I'm reading the wrong one. It is not that, it's West. I'm sorry. It is the West decision, West v. Washington State Association of District and Municipal Court Judges. This is the Court of Appeals case, 190 Wash App 931. That is the case that says it's the membership and functions. And I agree that it is the membership and functions. This is a Court of Appeals case that I am bound by in this matter. I'd also indicate, though, that in addition to looking at the membership and functions, the Court of Appeals in that case looked at GR 31.1, and which explicitly decides, or includes in its language, I should say, the association at issue in that matter. As GR 31.1 applies to this case, it would be sub K sub 1 sub 1. And it says it includes all judicial organizations that are overseen by a court, including entities that are designated as agencies, departments, committees, boards, commissions, task forces, and similar groups.
Objection, Your Honor. GR 31.1.
And I'm not going to hear from you, counsel, just yet. I will say that I recognize 31.1 did not apply at the time. I'm simply looking at this as some indicia from the Supreme Court as to what it believes falls within the definition of the judiciary for the purposes of this type of analysis. But I'm troubled by that in this case as to the county's argument, because it refers to a judicial organization, which seems somewhat circular and self-defining, but overseen by a court, and as currently composed, a law library in a county such as Lewis County only has one judge. It's a small minority of the board. Does the county see somewhere in the definition that is obvious on its face between a law library and the judicial branch? But a strong connection does not mean that in its essence, the function of a law library is the same as the function of a judiciary. As my question indicated during oral argument, in this court's opinion, if this law library at the county level were to be considered a part of the judiciary, so must the law libraries of a jail or a prison. And in this court's opinion, those law libraries are not parts of the judiciary. And I am aware of no authority indicating otherwise in that regard. But more fundamentally, when we look at the three cases that we have considered here, Nast and Koenig truly concern records that are judicial in nature that wouldn't really be disputed in any meaningful way that they are judicial records. The West case is more interesting because it is an association of judges, and portions of the records of that association could arguably be more on the penumbra of what one might consider to be judicial functions. However, as the Court of Appeals focused on in West, the core of that association truly hit upon the core functions of the judiciary: promulgating suggested rules, studying the operation of the courts, really looking at what directly impacts the court's functioning. That was the essence of that association in West. That is not the case here. We have a law library board, we have a law library, or we don't, but let's say that we did. As the court already indicated, the court will not allow this case to be decided on that factor. And law libraries can be used for a multitude of reasons, including considering issues of law that might be of interest to members of the public, including allowing attorneys to use it outside the existence of litigation. And really, in its core, the law library doesn't necessarily have to do with the functioning of the courts in terms of deciding cases. And thus, for that reason, this court finds that the function portion of this analysis weighs against the inclusion of a law library and its board as being a portion of the judiciary. That, when combined with the membership factor, which weighs strongly against the inclusion of a law library and its board as being a portion of the judiciary, necessitates the conclusion that there was a violation of the Public Records Act in this case for those reasons. With that being said, the court at this time would propose that the court set a date at a future Friday for a presentation of an order reflecting this court's ruling. And also at that time, this court would discuss with counsel the appropriate timing for the next step in this litigation, which would be the penalty portion of these proceedings. But I will hear from counsel first regarding what they believe might be the most fruitful way to proceed in this case. Mr. Carter?
I feel it's appropriate to have it be a court order, function. And,
Are you
Oh.
okay? Oh my God. Glenn, are you okay? Glenn, I got you. Can we get an ambulance?
Hold on.
Glenn, what should I lay him down?
Yes, can we get someone else?
Glenn, are you okay?
yeah,
You should sit down.
Yeah, get a seat here.
Hey, I'm in court right now, but there's
Court will be setting at this time a hearing in 2 weeks, indicating to the clerk, for presentation of an order on the court's ruling today. And we will discuss at that time next steps in this litigation. If the parties confer and believe a different course of conduct is appropriate in this case, they may communicate that ex parte to my judicial assistant, copying the other person, or confer with each other about the best way to communicate a possible change in that plan. But given where we're at right now, I'm just going to end this today. I've stated my ruling. We need an order, and I will set presentation of that order for 2 weeks from today. And I'm going to go off the record again now, having said that. Thank you.
Thank you, Your Honor.
thank you.
Thank you.